The Jack Daniels opinion and oral argument highlights another big issue in trademark law: the mismatch between liability doctrines on the one hand and defenses or other limiting doctrines on the other. At oral argument, Justice Jackson initiated this fascinating exchange.
But I wonder whether the cleaner, more sort of consistent with the statute way of looking at it is to ask, is the artist using this mark as a source identifier, as the threshold? And if they aren't, then I guess the Lanham Act doesn't apply because, as you've said, the Lanham Act worries about confusion that arises from use of a mark as a source identifier. So if they're not doing that, then there's no trademark problem. But if they are doing that, if it's being used as a source identifier, then I suppose we get into all of the questions under the Lanham Act test as to whether or not there's trademark infringement.
So the question is whether trademark claims should be limited to situations in which the defendant is using the plaintiff's mark as a mark and not for some other purpose. Now, whether you agree with that or not, it has an intuitive appeal. If we can say that songs like Barbie Girl aren't trademark uses in the first place, then maybe we can dispense with those sorts of cases without the need for the Rogers test or doctrines of that sort. But here was Lisa Blatt's response for Jack Daniels.
What's wrong with that?
Well, unfortunately, a lot. And with respect, that literally you're taking language in the text of parody and in the text of 1115b4, which you had a Supreme Court case on, KP permanent makeup, saying other designation of a source are actually exceptions under two statutory provisions that don't appear in infringement. So I'm fine with you making up stuff.
No, but I'm not making it up. I mean, you said here this morning, and I wrote it down, that the whole confusion issue. Do you agree that confusion is the heart of the Lanham Act?
Confusion has nothing to do with designation of source.
This was kind of obnoxiously delivered.
I'm fine with you making up stuff.
But Blatt actually does make a plausible statutory argument. Bear with me. She's referring to 15 U.S.C. section 1115b4, otherwise known as section 33b4 of the Lanham Act. Section 33b refers to the defenses to which marks are subject even if they achieve what's known as incontestable status. These defenses reflect traditional common law limitations on trademark rights, and in older litigation, the Supreme Court has suggested that with respect to incontestable marks, the list is closed. Now, this reflects a fundamental problem with the Lanham Act. Trademark liability is determined via the vague likelihood of confusion standard that functions as an inkblot, in which judges can often see what they want to see. In contrast, defenses are limited. At the very least, there is no provision in the Lanham Act that invites courts to deem certain kinds of acts as being insulated because they say promote consumer welfare in the aggregate. Instead, courts are limited to discrete doctrines like classic fair use or functionality or that sort of thing. Now, some courts have tried to craft limiting doctrines out of the likelihood of confusion standard. Indeed, you could look at Rogers as being an effort in this kind of vein, the idea that expressive uses are simply not confusing in the first place. And Rogers, of course, draws further power from the force exerted by the First Amendment.
Well, I'm concerned about the First Amendment implications of your position. And you began by stressing that Rogers is atextual, it was made up. There is a text that says that Congress shall make no law infringing the freedom of speech. That's a text that takes precedence over the Lanham Act.
But this approach collides with a tendency to treat trademark cases as simple fact-finding affairs, as I talked about in the last video. So courts can just as easily say that if a defense or a limitation to trademark rights isn't named specifically in the Lanham Act, then it isn't part of trademark law, full stop. And in Jack Daniels, a concurrence by Justice Gorsuch joined by Justices Thomas and Barrett shows some potential receptiveness to that argument on the part of the justices. And indeed, in this case, a sort of strict textualist view carried the day with regard to the dilution question. Recall that Jack Daniels had a claim against VIP that said that the chew toy was likely to tarnish the Jack Daniels brand given the product's poop associations. Now, the Ninth Circuit had held that there was no tarnishment claim available because the dilution statute has an exclusion for non-commercial speech. On this view, the chew toy qualifies because the toy had non-commercial elements. That is, it was expressive. As the court said, although VIP used JDPI's trade dress and bottle design to sell bad spaniels, they were also used to convey a humorous message. that message is protected by the First Amendment. Now, the Ninth Circuit has been here before. An earlier precedent, the Ninth Circuit said that the name Barbie Girl, when used for a song, was non-commercial given that it had an expressive component. And so that's the logic the Ninth Circuit applied in the Jack Daniels case. Not so fast, said the Supreme Court. Justice Kagan's opinion writes that, however wide the scope of the non-commercial use exclusion, it cannot include, as the Ninth Circuit thought, every parody or humorous commentary. Now, why is that? Well, it's because the Lanham Act's dilution provision includes a fair use defense that, quote, specifically covers uses parodying, criticizing, or commenting on a famous mark owner, unquote. Now, that specific defense was unavailable to VIP given its purported use of its trade dress as a mark, as we talked about in an earlier video. But for the court, the mere mention of parody in this other provision dooms the application of the non-commercial use clause as a matter of logic in this case. After all, if the non-commercial exclusion protects VIP's parodic use as a mark, then the fair use provision in the dilution statute, which only excludes uses if they are not uses as a mark, becomes superfluous. As Justice Kagan puts it in her opinion, given the fair use provision's carve-out, parody and criticism and commentary, humorous or otherwise, is exempt from liability only if it is not used to designate source. Whereas on the Ninth Circuit's view, parody is always exempt, regardless whether it designates source. The expansive view of the non-commercial use exclusion effectively nullifies Congress's express limit on the fair use exclusion for parody, etc. Now, is that plausible? Sure. But it's most plausible if we were considering the Lanham Act as a statute that was drafted and enacted all at once as a unified whole. That ain't the Lanham Act. It's been subject to numerous amendments and additions since its initial passage in 1946. And in fact, that's true of the dilution provision, which wasn't added to the statute until 1996, and that's also when the non-commercial use exclusion was enacted. At the time, in contrast, there was not even any specific language about tarnishment, nor this parody exclusion on which the court placed so much weight in the Jack Daniels opinion. Both of those came later. They came in 2006. Congress added the parody exclusion but retained the pre-existing language on non-commercial use without any kind of change. So given that, it's a bit of a leap to assume, as the court seems to, that Congress meant to use the parody exclusion as a way of implicitly reining in the scope of the non-commercial use exclusion. There's lots of reasons for thinking that. First, there is no mention in the legislative history of any such intent, and the Ninth Circuit had already given the provision the interpretation that the Supreme Court would later rule unacceptable in Jack Daniels. It seems that if Congress had a problem with that interpretation, they could have said something about it, or amended the non-commercial use exclusion, but they didn't. Moreover, the larger context of the amendment suggests that the parody exclusion was added in order to expand, not contract, the scope of dilution defenses. This is because these amendments were intended to undo a Supreme Court ruling that had construed the dilution cause of action narrowly. Specifically, and it's not really relevant to Jack Daniels, but the court had determined that a dilution plaintiff had to prove actual dilution, but Congress decided they wanted a likelihood of dilution to be good enough for liability, and in addition to that amendment, Congress added the tarnishment provisions. Now, these changes prompted concern about the potential burden on expressive speech that would be posed by the dilution cause of action. And that's what led the drafters to add the parody defense. Now, there was a prepared statement by one of the representatives, Howard Berman, ranking member of the Subcommittee on Courts, Internet, and Intellectual Property, and he explained that in the amendment process, the ACLU voiced concerns about the possibility that critics could be stifled by the threat of an injunction for mere likelihood of tarnishment. And that's what led to the drafting of a separate exemption from a dilution cause of action for parody, comment, and criticism. In other words, Congress's apparent intent regarding the parody exclusion was to broaden dilution defenses, not contract them. But perversely, in Jack Daniels, the court reads the addition of the parody exclusion as a contraction of dilution defenses. It effectively reads the new parody defense as a de facto amendment that implicitly redefined the pre-existing non-commercial exclusion. Nothing in Jack Daniels' opinion or oral argument shows any awareness whatsoever among the justices of this issue. The opinion treats the Lanham Act as a statute that was enacted all at once and whose provisions should be read accordingly. Now, to be sure, it's not that there aren't arguments in defense of what the court did here. The amendments I'm talking about were, in fact, a full rewrite of the Lanham Act's dilution cause of action, so maybe it's fair to read the provision as being enacted all at once, even though the pre-existing non-commercial use provision was reenacted unchanged. And as for the legislative history, well, the court these days is generally not sympathetic to arguments that are based on congressional intent or legislative history, and there are justices who prefer to treat the text as the text, no matter how silly the result of doing so might be.
Well, I think we're all textualists now in a way that just, was not remotely true when Justice Scalia joined the bench.
And of course, maybe the court just thought the earlier precedent on the scope of the non-commercial use provision was just simply wrong. Fine, but the fact that the Jack Daniels court could not be bothered to articulate any of those, or maybe some other, arguments, suggests a willingness to engage in a fairly lazy form of textualism when it's convenient. And if that's the case, so much the worse for limitations to trademark doctrine when we consider how broadly the infringement cause of action can be read in the first place.